So, hello everyone. Warm welcome, and I would like to thank all you parents for taking your time off on a holiday. It's a long weekend, and still you decided to prioritize this over other things. My name is Ujjwal. I serve as a part of the admissions team at Indian Autism Center. Like most of you, I'm also a parent. I'm an MBA from IIM Bangalore. I have spent 20 years across marquee brands like Colgate, Kellogg, Horlicks, Saffola, and Zandu. In my last corporate role, I was vice president at Imami, where I managed a 500 crore business, managing all India sales of e-commerce, malls, and supermarkets. I came across IAC 4 years ago when I was the deputy director of IIM Bangalore Alumni Association. IAC had sponsored a Pan B School alumni meet. When I asked them why this non-for-profit organization is sponsoring this event, they said we hope to build an organization that will have the stature of the IIMs and would want to hire talent from the IIMs. I followed their activities on social media and was enamored by their bold vision. 2 years later, I decided to quit my corporate job and cross over to IAC to build something more purposeful that is on a mission to complete the unfinished job of God and provide world-class ecosystem of autism care. I will like to play a corporate AV. So one second, I'll just play the videos. One second, give me a moment. One second. Give me a moment.
1 month.
Sorry.
Can you hear me? Can you see the screen? Anita, you can see the.
No, the screen is not visible.
Sorry.
Now we can see.
One of its kind facility, if I may say, in the world. When fully completed after all the phases, we should be a home to 600 individuals and their families under the spectrum. We aspire to create a global ecosystem where we are able to handle anything and everything about autism.
Yeah, myself, Manashi, Agniv's mother. My dream was to have a place where after me, Agniv can live. I mean, the place where the quality of life, what I was giving to Agniv, that should continue. As a mother, I am looking for a secured place, a place where Agniv can be happy. So, a better life a mother wants for a kid. That is all that I can say.
I think this place is going to help a lot of people because it has a learning center, it has the environment, it has the potential to actually grow people and give them the bandwidth and the platform that they deserve. Overall, it felt wonderful to be in the middle of such a greenery environment. I think the environment that you place people in matters a lot.
Huge place, well planned, and I think this will be one of the greatest projects in the country.
Hi, I'm Preeti Dhanuka. I have come here for my sister who is intellectually disabled and she's 42 years old.
Oh, hi, I'm Reena Murarka. We have come here for my daughter Rashmi Murarka. She's 42 years old and we were really looking for such project where she will be cared for and we will also be at peace. So it's a great initiative and it will help a lot of people in Kolkata and West Bengal because there's nothing like this have come up as yet.
The campus is exactly what we were told. It is really the working style, the team, the management, everything looks very promising. So we are really looking forward to the setup and the institution coming up.
I think the vision is remarkable. The green space the vastness of the space is ripe for development of therapeutic space.
The children who fall under the spectrum will have an opportunity to interact with nature. They can see the rabbits running around, they can see the cows which are going to be placed in the Goshala which is coming up. I find this campus to be so inclusive.
Let me play the second AV.
Life with autism comes with challenges, but often the real barrier is not autism itself, but the world's perceptions around it. The India Autism Center is driving that change by building a world-class ecosystem of care, one that goes beyond therapy, empowers the neurodiverse community, and enables individuals to live with independence, purpose, and dignity.
IAC is being designed to last forever. Homes to kids after their parents are gone or old or weak. The IAC with best people, with best intentions, and a place which is designed for perpetuity, I'm sure will become a place of excellence.
Individuals with autism need compassion, understanding, and informed care. Yet, there is a critical shortage of trained professionals and educators. Manan, the training wing of the India Autism Center, is bridging this gap through expert-led learning, hands-on training, and internships, equipping professionals to make a real impact.
Manan is currently training people in large numbers, and we hope to offer skill-based employment to at least about 2,000 people in the next 4 to 5 years.
Okay, quickly about India Autism Center. Our founder, Mr. Suresh Somani and Amita Somani, started something called Amrit Somani Memorial Center 18 years back. It's a daycare center, ABA center, which runs in Calcutta. And the genesis of India Autism Center was laid in 2019 when we started with an international conference on autism, which was again done in 2020, just before COVID. These two international conferences laid the foundation of India Autism Center, thinking on what world-class ecosystem means. And we had participants from across the world, including US, UK, Peru, who shared their best practices on autism care, on research, on residential facilities, on training. That became the building block of what current India Autism Center is. In 2021, we started with our research department, and where research on autism has been for the last 4 or 5 years. We've been doing a lot of research and publishing papers. In 2024, we started with a training academy where we are training caregivers under the umbrella of Rehabilitation Council of India. And these courses are meant captive, where our caregivers are trained for 6 months on how to take care of autistic individuals. And Samavesh, which you're all aware, would be opening its doors by the end of this year. This is how the master plan looks like. This is spread over 52 acres. The periphery of the campus is 4.5 kilometers. It's a very expansive project. It's like a township for all sorts, which has got everything from a vocational training center to a clinic to a OPD section, dance and music therapy block, staff housing for parents, housing for assisted living. So it is a very expansive campus, a temple at the periphery. So it is a very wide campus with a lot of greenery and a lot of water bodies around. Our guiding principles are simple: live, learn, evolve. So it is not answering to the question of what next, but we are saying what after us, but it is saying what next. It's about how an autistic individual can live to his fullest with dignity, can learn new skills, new vocational skills, or other special education skills, and evolve and reach to his true potential. So it is more than just what after us, it is saying what next for the child, for your special child. Our programs are a mixture of three things, three verticals. One is long stay program where we can take care of the child for life with our assisted living facility. Then we have short stays, which will be 3 to 6 months program for high functioning and individuals with mild autism, which will be programs which will be linked to milestones of how to, it could be school readiness program, it could be puberty and managing that, or pre-vocational training programs. And of course, there's a new addition. We have tied up with Ruskin Mill Trust of UK, under which we'll offer their graduation programs in India. This will be 3 4 year long programs aiming to help mainstream and integrate high functioning individuals. Our vocational training, there are going to be a whole lot of gamut of activities, right from baking, handicraft, pottery, blacksmithing, carpentry, horticulture, agriculture, animal care, computer and logistics training, all under the aegis of Ruskin Mill Trust. I told you about Ruskin Mill Trust. It is a 40-year-old organization with 17 colleges across United Kingdom, where 1,500 students graduate every year, who are imparted vocational training diplomas. And they believe a use of it is more therapeutic in nature, which calms people down and at the same time is build independence in their lives. From a clinical services, we will have a whole range of services, the regular ones like occupation therapy, physiotherapy, to even interesting therapies and novel therapies like animal assisted therapies. Of course, we'll have a nutritionist on board and trained staff to take care with an individualized care plan for each of the individuals. We will have a medical center which will um, we will have a medical center. Preemptive nursing will be there. 24/7 ambulance will be there. There will be alternate therapies like Ayurveda, homeopathy, which are also known to have calming effects on autistic individuals. Of course, there'll be recreation, outdoor sports, movies, swimming, cafes, temple. We will also help individuals with legal guardianship guidance, trust formation, nominee and inheritance planning. And to this goal is the today's webinar that we have planned. We are a professional organization. There are 13 heads with across department. There's one CEO and 12 heads across departments, which are all with professional backgrounds, just like a corporate organization structure. We run that place like a corporate organization structure. We also have a board. The board is represented by people who are otherwise board members of Akshay Patra Trust. There is someone from from the Tata Group who is the CEO there, is also on a board. So there are four board advisors that we have who are who in turn guide the CEO and the founder. This is how the project will look like: minimalistic, simple, not pretentious, very functional architecture would be there. Our project is 70% complete. These are some actual pictures of the site, and we hope to start operations by the year end. Great pleasure
That's
to
it from
introduce my expert speaker of the evening, Mr. Jitender Solanki. He is the founder and director of Special Needs Estate Planners Private Limited. He is a SEBI registered investment advisor specializing in holistic financial planning and wealth management of parents with special needs children. He has over 17 years of experience in this field and 11 years as an entrepreneur. He is also an author of the book Financial Planning for Special Needs Children Families, which addresses the unique financial challenges faced by families with dependents who have special needs. Over to you, Mr. Solanki.
Thanks, Ujjwal. Let me share my PPT. 1 second. Okay. Right. Okay.
We can see your screens. We can see your screen. Go ahead.
Thanks. So straight away going to topic. So we'll talk about estate planning. Special Need Estate Planners Private Limited. So it's a company we're completely focused on advising special dependent families on estate and succession planning. So today's we'll look at some key issues for consideration. We'll understand will and trust and how basically we can plan when we are thinking of creating a secure future for our child. So we will look at some of the tools of major tools of estate planning which each family understands and need to have. First of all, guardianship. Guardianship is very important because in the eyes of law, when we talk in legality, so once a child turns 18, then he does not require a guardianship, which means like you and me, everybody is free to take their own decisions. But when you have a child with disability, then and whenever you have to take decision on the child behalf, be it personal, be it financial, you will always need that legal capacity, legal authority, and that's what guardianship comes in. So it's a basically a court-approved legal relationship between a competent adult like your child or a minor or anybody with person with disability or somebody who might be incapacitated, and it gives guardian a very defined degree of authority to act on the behalf of person, which means once you are a guardian, so you can act on your child behalf for both personal and financial matters. So why guardianship may be required? Some facts. So the individual might have assets which he or she cannot adequately manage. So someone is needed to manage those assets. Person might needs medical care or other services that will not be provided unless there is a clear understanding about personal legal capacity. So it comes to the situation like you have a neurodevelopment child, and suppose the it comes to about his medical care, then the medical institution, if comes to know about his legal capacity to decide, will always ask for someone who have the capacity to make that informed consent or informed decision. And then the picture of legal authority will come in, that at what legal authority you are deciding on that behalf. As I said, in the law, after child turns 18, for minor children, the no question asked because you are a natural guardian. But that natural guardianship ends once the child turns 18. Then whenever you have to take a decision, you need that legal authority. Okay, so you are parents, after a parent, the sibling, whoever wants to take the decision on the child behalf will have to take the guardianship. Okay, so I'll address more on legal guardianship on through FAQs. Now, when to seek legal guardianship? So, when is the time to take up legal guardianship? As I said, once the child turns 18, now the law says that that once the child turns 18, then he or she is an adult. So, an adult person is capable of taking decision like you and me. But as a parent, when you say that no, he can't take those decisions, we are going to take decision on his behalf, then you have to take a guardianship. So when to seek legal guardianship? Once the child turns 18, then you have to take the legal guardianship. What is the responsibility? A legal guardianship written very clearly in the law, that what a role does a legal guardianship play? A legal guardianship, a legal guardian play a role of managing both personal and financial affairs. So whatever personal decision has to be taken for the child benefit, on the child behalf, or any decision taken on managing those assets, for example, any property in the name of the child, any bank account in the name of the child, or any financial asset in the name of the child, all those decisions are taken by the legal guardian. And the legal guardian has to take decisions only for the child benefit. No property, no decision can be for personal benefit, and that's a legal responsibility which a legal guardian has to take. Do parents have to obtain legal guardianship when child turns 18? Yes, parents have to obtain, but in a situation where the parent take a decision that these are the matters where I have to decide on my child behalf. See, the RPWD Act 2016, it talks about limited guardianship with the consent of the person with disability. Now, whether your child is can give that consent maybe to a certain extent, but may not be on the financial matters. Okay, so in that case, you go for a full legal guardianship, and that so the legal guardianship has to be obtained. That legal guardianship certificate you get is the legal authority. Now, what is the process of obtaining legal guardianship? So there are two ways when you can obtain legal guardianship. One, the national trust. So national trust is a government body formed in 1999 to take up the legal guardianship process. So you can apply through national trust, or you apply through the district court. The national trust has those specific disabilities on which it gives you the legal guardianship, and autism is one of them. So what is the process? There is an online application form. You have to fill up that application form. Then you are called for an assessment on a particular day with all the documents records, and then you are given the guardianship certificate. That's a national trust process. Any maybe complexity, probably you might have to go through the district court. So, and court means, the number of hearings or the court process, it will take its own time. Now, can NRIs, including siblings, seek legal guardianship, or can they take legal guardianship? Uh, National Trust does not allow NRIs or anybody abroad to take up legal guardianship. For NRIs, even the siblings who are residing abroad, they will have to probably approach the district court and take the guardianship. It's not that guardianship is not given. Yes, guardianship is given, but probably they will have to go through the district court. Can a non-profit organization like an IAC become a legal guardian? Yes, there is a provision in the National Trust Act that any NGO, any non-profit organization who is registered with National Trust can take up the legal guardianship. So yes, non-profit organization can take up a legal guardianship. What if the child has an OCI NRI status? Okay, so if the child has an OCI NRI status, but if he is residing in India, then there is no change in the law, as far as legal guardianship is concerned. Parents are the biological parents. Okay, they are considered as a biological guardian. So there is no change in the law when, even if the child has that status and residing in India. But it's only when, if he or she is residing abroad, so then the situation comes in whether he will be given a guardianship in India or not. But as far as this status is concerned, till the time he is a resident Indian, then the guardianship would be given. Is there any monitoring process for legal guardianship? Only the National Trust has that monitoring process, wherein every year you as a guardian has to submit certain documents on the assets which the guardian owns. Every year you have to submit to the National Trust. Otherwise, there is no as such legal authority. Beyond National Trust, it's only the court where the matters of legal guardianship are taken up. So only the National Trust has this monitoring process. Whom to complain if LG does not work as per criteria? So as I said, National Trust has that monitoring authority for the disabilities which National Trust takes care of. So that's on legal guardianship. Probably we'll take up questions, any questions at the end. Coming to will. So why will is so important? Okay, why write a will? So let's understand what happens when you do not write a will. Now, if you do not have a will, so what happens? The distribution happens as per the Indian Succession Act. Now, Indian Succession Act, there is, let's say for Hindus, there is a Hindu Succession Act. Now, what does the Act says? The Act lists down the class of legal heirs, class 1, class 2, class 3. Now, for male Hindu, wife, children, mother are the class 1 legal heirs. The Act simply says that if there is no will, the distribution will happen according to this Act. And the Act says that whatever the assets this person owned at the time of death, that should be equally distributed between the legal heirs. That's what the Act says. Now, when you have a special need child, you want some specific provisions. You do not want the distribution in such manner. And that's why it's become important that you write a will. The importance of will comes in. So it's a legal document that coordinates the distribution of your asset after your death. Or specifically the will, it tells everyone that how do you wanted the distribution of your asset after your death. So why will what you can do in a will, and that's why I said, when you do not have a will, so act has a very straightforward distribution, but you do not want that distribution. You want specific bequest and direction in your will that how your assets should be managed. And these kind of specific bequest can actually relate to providing a corpus. So you can even write in the will that you have uh, allocated a certain corpus for your child, and that should be utilized to meet his or her maintenance and medical care or any other needs. So a will, in a will, you can write a detailed bequest for the specific care of your child, how the money should be utilized for the specific care of your child. Also about the home care in your residential property. So if suppose the child is going to stay in the home, okay, and the support system has to be provided in the home, the will can write that specific provision also. So you can write in the will that how this support system would be provided, how the supports would be hired, and how these are going to be managed for the benefit of your child. Appointment of legal guardian. So as a parent, you have taken the legal guardian, but we are answering question what after us. And when it comes to what after us, both personal and financial affairs become important. Now, who is going to be the person after your lifetime who will manage the affairs? And if you identify somebody, you're going to write that person in your will. Even when you want to appoint, let's say, organization like IAC, so you will write your wish in the will that this organization should take up the legal guardianship of my child, and the legal guardian will have to go through the process of obtaining the legal guardianship certificate, but on the basis of the will, as your desire, as your wish, that organization or individual can go and obtain the legal guardianship. So will is also important for mentioning the future caretaker of your child. Setting of a trust through will, it can happen so that the trust becomes effective at the distribution of the assets at your death. So you can set up even a detailed trust in your will also. And you can appoint trustees, successor trustees, appointment of a protector will come to it. Who are these people? But you can appoint specific people for managing your trust. And provision of distribution of income of the trust for benefit of the child. So you can even write in the will that how this income should be distributed for benefit of my child. So you look at what a will can do. Now, when you talk about not having a will, nothing is going to happen, because that's what not the law says. The law simply says that the simply distribute them to all the legal heirs equally. Now, where is the issue? Let's say there is a property. Now, it's not going to happen that the property, all the legal heirs will have their ownership. Now, that's what you do not want. You have a special need child. You want specific provision for your child, and that can happen only when you write a will. So that's why will writing is so important. And also the what happens after your child lifetime, where will those assets go, that also you describe in your will. So just look at these 7 or 8 points and you can understand that what a will can write, and you can write anything, everything about your child care with respect to the money you have accumulated for his or her benefit. What sections a will should contain? So personal details, so your name, father name, residential address, declaration of date. So when this will is written, the date should be important. Validate free will. So you can mention that you were not under any influence or you were not forced to prepare this will by any person. Provide executor details. So executor is a person who is going to take care of the distribution process. And it's very important because that executor is the person who will manage that entire process. So you need to have somebody appointed to manage that entire process. Because generally when we come on the emotional aspect, so your family might not be in that situation to take up instantly, so somebody should be there who can maintain, who can manage this process. The court also, the executor is the person who is going to manage the process in the court also. So the executor is very important for your will. Details of assets and beneficiaries, so you give all details of your asset and how the distribution is going to happen, which assets are going to go to the trust, which assets are going to which legal hire. So you give clear details of each and every asset. And lastly, the will requires signature of yours plus signature of two witnesses are required in your will. These are specific sections. You can write more than this, but these are largely those sections which are important whenever you are drafting your will. Registration of will. So under registration act, registration of will is not mandatory. So even in a witnesses signed by the testator is a very well accepted will, but registration is advisable. Why say? If it is registered, will cannot be tampered, destroyed, stolen. So nobody can change the will. Original will always remain in the custody of the sub registrar, and access to that registered will require written permission. So nobody can access that will. And since the will is registered, today not ready to accept unregistered will. So if there is, so that may be a bit of lengthier process. But if there is a registered will, then probably the execution will happen much faster. So registration of a will is not mandatory, but advisable at any time that you should get it registered. Okay, I'll just talk brief about probate. So there is a probate process happen. Now, what is a probate? A probate is court certifying the legal characters of the legal hires, or effectively certifying the will then. Okay, I mean, we have seen all in movies, Hindi movies, that will going for a dispute and going to the court process, that is actually a probate process. So it can happen that there is a dispute in the family. You might have multiple assets in multiple states. Okay, so all these are situations where will might go towards the court process for a probate. And a probate is generally a 6 months to 1 year process. Till the probate process happens, no distribution is going to be effective. It's the court's direction. Court can do it for any specific things, but the distribution will happen after the probate process is completed. So that's on will writing. Let's come to the trust. Why a trust is required and why it is so important, especially for special children families, and why we are advising, why we are saying that you should form a trust. Now, generally, what is a trust? In a simple language, what actually trust is? Trust is an arrangement. It's not a separate legal entity as such who has its own taxation or on the legal standing, but it's a legal arrangement wherein you as a parent, you can call yourself a sponsor or settler. So you person, they will hold and manage these assets for the benefit of your child. So that's a legal arrangement you are making for the financial care of your child for complete lifetime. Now, what are the elements of trust on which the trust is formed? First of all, there has to be an author or settler of the trust. Now, who is a settler? A person who creates the trust. Now, who can create the trust? Parents can create the trust, grandparents can create the trust, or legal guardian can create the trust. So you need to have a interest in creating the trust. No third person would can create a trust for your child. There will be many legal hurdles in that. Okay, but largely when you are creating the trust, you are called a settler. So parents, grandparents, or legal guardian, these are the three individuals who can create the trust for the benefit of the child. Trustees, persons who manages the trust. So trustees are going to be people who will manage the trust. Beneficiaries, for whom the trust is created. So your child is the beneficiary of the trust. trust property or subject matter. So the assets which are going to be transferred to the trust, which the trust will manage, is called as trust property and objective of the trust. Why a trust being created? So that objective of the trust is trust purpose. Now these are the 5 elements on which a trust is formed, right? Any of the element is missing, probably the trust won't be complete. But these are the 5 elements on which the trust is largely created. Now, in India, we have two kind of trust which are created, largely public trust and private trust. Now, public trust is all those charitable trusts are known as public trust, where beneficiary is public. Whereas in private trust is or we name them as a private family trust, where benefits are only specific individuals related to the settler, related to the person who is creating the trust. So when a parent create a trust for their children, then it is called a private trust. Also, private trust beneficiary has to be a relation with the settler. Now, sometimes these queries come up: can 2 or 3, 4 parents, come together and form a private trust for their children? No, it's not going to happen, because the beneficiaries and settlers are not related to each other. You have multiple beneficiaries who are not related, plus you have multiple settlers who are not related. So it's private trust is specifically a family trust, you can name it. Okay, something more on the private trust. So there are first of all 2 kind of private trust which can be created. One is a revocable and one is an irrevocable trust. A revocable trust is largely a trust wherein you have the power to dissolve the trust at any point of time. So when you are parents creating a trust, and if a revocable trust is created, you will have all the powers to revoke the trust at any point of time. Now in a revocable trust, the income of the trust is as good as your income. So it is added to your income and become taxable at your tax rate. Also, the assets are treated as good as your asset. So because why? Simply because it is revocable. The second is an irrevocable trust. An irrevocable trust is where you do not have powers to revoke it or dissolve it. It gets dissolved when the objective is completed. And in an irrevocable trust, the income and the taxation varies with respect to the revocable trust. So these are the 2 type of trust which you create. Now, what are the taxation with related to trust? Taxation depends on 2 kind of structures. Even within these, there are 2 structures. One is a specific and one is a discretionary. A specific trust is one where the income is completely defined. So let's say you have 2 beneficiaries. The trust says 60% give to one, 40% give to other beneficiary. So the income is clearly defined. Discretionary trust. A discretionary trust is where the trustees are deciding how the income is going to be distributed to these 2 beneficiaries. That's called a discretionary trust. When you have only one beneficiary, you can consider largely it is going to be a specific trust. So these are the kind of structures which private family trust have in India. Now, based on what are your family dynamics, how do you want to create a trust? You can create a specific structure of the trust. Now, what is the benefits of trust? Creating a trust. Why I am talking about private trust? First of all, there is no restriction on settlers or those who can create the trust. As I said, parents, grandparents, or legal guardian, they can create the trust. There are no standard terms of the trust. So when you write a trust deed provision, it will you have in the trust, it is going to carry. So in the trust deed, there are no standard terms. Each family, based on what you want for your child, you can create the terms of the trust. You can have people involved in the trust. It's a separate legal arrangement. It's a completely separate legal arrangement, not connected to will or anything else. A trust does not go through probate. So a will can go to court for testification, but trust does not go through court. So one of the bigger advantages is that even if a will is in a probate, your trust can continue taking care of your child financially. Whoever create the trust can appoint the initial trustee. So when you are creating the trust, you can identify and appoint the initial trustees. A trust works only for the beneficiary. There is no other objective. The objective of the trust is that whoever is the beneficiary in the trust works for that. And most importantly, when your family knows that there is a private trust you have created for the benefit of the child, is there's going to be less conflict among the family members because they know that why this trust is created. uh, in India we do not have a definition called special need trust. That's largely come from the US, where you have a separate law altogether for SNT. In India everything falls under private family trust. Okay, let's demystify trust. So we'll go through some of the FAQs and see what probable structures or what other queries we can have on the trust. What are the types of trust shall be created, irrevocable or revocable? Okay, when these two structures are important. Revocable is when you are not sure on certain things. You think that might be I might have to change certain aspect of the trust. Okay. Or there are other situations where, let's say, when you have multiple properties in multiple states, you create a revocable trust and bring it under revocable. It finally an irrevocable trust. Now, one of the bigger advantage of trust is giving the asset protection. That once the assets are transferred to the trust, it's a trust property. Then others can claim on this asset, neither of your family members. That asset protection comes largely in an irrevocable trust, not a revocable trust. So now a revocable, you can create initial revocable trust initially and might convert it. Let's say after 5 years, you find this is the trust I want to have. So you can convert it to an irrevocable trust, or at your death, the trust can get converted to an irrevocable trust. So what type of trust shall be created? You, as you know, think all along your family dynamics, what do you want, and then you can create a trust. Who is the settler and what is the relation with the beneficiary? The settler, we have looked at it, it's the person who create the trust, and generally he is related with the beneficiary. So grandparents, when they create, they have a relation. Legal guardian has a legal relationship with the beneficiary of managing his affairs, thinking about his benefits. Okay, so settler is somebody who has some relation with the beneficiary. Can there be multiple beneficiaries? Yes, there can be multiple beneficiaries. There are trusts being created where along with the child, even the parents are the beneficiaries. So you can have a trust with both child and parents also as the beneficiaries. So you can have multiple beneficiaries in a private family trust. Who are beneficiaries of the trust? Largely, as I said, the child is the beneficiary. When I'm talking about special need children families, even the parents can be the beneficiary. So the same trust will take care of the parents even their but beneficiaries are going to be family members, not outside family members. So you cannot have somebody else out from outside the family becoming a family member, becoming a beneficiary of the trust. So they are largely going to be the family members. Can child with OCI and NRI status be beneficiary of the trust? What if parent has the same status? Okay, so all these queries are important. Okay, but as far as the status is concerned, see, till in any of these status, residing in India, so you have a resident status. Even if you have an OCI card, you have a resident status. So it's perfectly fine. You can create the trust. Now, where the complication will arise in India, the parents are abroad, or any foreign fund is coming to the trust. Maybe somebody abroad who is gifting the money to the trust. So you have FEMA rules, being applicable in the trust. So till the time you are resident of India, till the time you are residing in India, till the time the funds are being transferred from India, there is not going to be any issue. When the person, either the beneficiary or the settler residing abroad, or the funds are coming from the abroad, then there are other rules and regulation which gets applicable. Or if the trust is sending money abroad, then the rules and regulation will apply. The FEMA rule, the taxation rule might vary, whether it is considered as global income or not. So all those equations will come into picture. So everything is very simple till the time the resident is in India. Even with that status also, if you are residing in India, you are considered as a resident Indian, no problem. Shall family members leave personal property specifically to the trust and not to the special need child? Yes. If the trust is created, then the properties to the trust. Now, is there any tax implication for the trust? So that family members are gifting to the trust, and you have a gifting regulations in the income tax that, so if the gift exempted. The similar rule apply if the person gifting the money to the trust, if it is in relation with the beneficiary and under that same regulation or same list of people written in the Income Tax Act, okay, then there will be no tax implication. But beyond that, anything beyond those blood relatives, anyone who send money or property to the trust, then there will be a tax implication. But largely, when any family member wants to gift something to the child, then gift it to the trust. Can settler or any of the trustees become the beneficiaries? Yes. I have spoken about parents becoming the settlers. Now we have created structures where parents are the settler also, parents are the trustees also, parents are also one of the beneficiaries. So those kind of structures can be created. If the trustee ceases to act, do their power pass on to anyone else? And if so, who? So, okay. So what is the provision now? So you have 2, 3 trustees. One of the trustees ceases to act, maybe death, maybe he's resigned. Then the next trustee will take over. You might have mentioned in the trustee, or there is some provision with minimum number of trustees. Let's say the trust says it has to have minimum number of 2 trustees. One trustee dies. Then whoever is the existing trustees, either he appoints another trustee, or if you have written in the trust deed that after any of the trustee leaves or dies, then this person should become the trustee. So the powers will pass on to somebody else coming in his role or her role as the next trustee. Can settler be given exceptional vetting powers for all decisions? Yes, there in the trust, the settler can have those powers. Can anyone be given powers to unilaterally remove the trustees? Settler can do it, surely. Settler can have those powers. Then there is a role of a protector. Uh, uh, let's say you have some family member abroad, you want to involve them as a trustee. They might have powers to remove the trustees that can be given in certain conditions. So can anyone be given? Yes, it can be given. But as I said, with certain conditions. Who can transfer the fund to the trust directly and who can give to the trust? I have spoken about this, that largely the blood relatives, they can give to the trust, though anybody can gift it to the trust, but the blood relation, the family member relation will come into picture from the taxation perspective. Whether that gift is going to be taxable for the trust or not will depend on the relation of the person who with the beneficiary who is asset class. So when the trust is a private family trust in India can invest in multiple asset classes, whether equities, bonds, mutual funds, shares, venture capitalist, VC funding, or private equity, whatever asset class you name about, a private family trust can invest anywhere within the provision you have given in the trust deeds. Trust deed mentions where the trust can invest. How be the trust fund distributed on dissolution or death of the beneficiary? So when you as a settler creating the trust, you write it that how it is going to be distributed if the trust get dissolved. If you have not written, let's say, for example, then largely it goes as per the Succession Act. So whoever is the next legal beneficiary of the child as per the Succession Act, the asset will be distributed to him or her. So generally, when in all the trust deed we create, so we write it in the provision. Whether you can write it in the trust deed also, you can write it in the will also, because you're going to mention in the will that this fund these assets should go to this trust which I have created for the benefit of my child. But you largely mention we name them as residual beneficiary, that after the death of the primary beneficiary, who is going to own those assets when the trust get dissolved.
5 more minutes, Jitender.
Beneficiary dies, yeah, the objective gets completed. So the trust will get dissolved in both the situations. Okay. Who is a trustee? So trustee is an individual who manages the affairs of the trust, and his role is to make profitable decisions for the entity. Okay, FAQs, who can be trustees? Anybody can be trustee, whether it's an individual or organizations, they can become trustee. Can family member be trustee? Yes. Can NRI become a trustee? No. The Indian Trust Act specifically says that if any trustee resides more than 6 months abroad, then he should be replaced. What are roles and responsibilities of a trustee? A trustee has to think like a parent. What's going to happen with the corpus? Where it should be invested? How it is going to sustain long term? What should be done? Who is going to be the next person after me? So trustee has to think on all those lines. Can trustee be added later? Yes, you can add trustees later on. You can remove the trustees later on. Who can remove the trustees? Either the settler can remove the trustees, or the group of trustees. When you have, say, suppose 5 trustees, if one trustee does a mischief, the 4 trustees can remove that trustee. Can trustee decide on the personal affair of the beneficiary? To a certain extent, yes, but largely this is the role of the legal guardian. If the trustee ceases to act, do their power pass it to anyone else? As per the provision, yes, somebody else will come in as a trustee. Does the trustee need consent approval of any other person for distribution? As per the trust, no, but yes, if you appoint a protector and if you say the trustee should consult protector because he is a family member to take decision, then they will take, but trustees are not bound to accept that decision. The trustees can say no, we won't accept this, and can take their own decision, because in a private trust, the trustees are the final legal authority. Do the trustees exercise power independently or control on subject to approval by any person entity? No, it's they are taking all in decision independently. They are not controlled by any other person. Who succeeds if the trustee leaves or dies? The next trustee comes into picture. He can be individual or professional or a corporate body. Okay, so what we offer as a organization, we offer estate planning solutions, we do will and trust creation. We also offer trusteeship and trust advisory services for the trust which are created. Okay, so that's all on the estate planning solution. So happy to take questions now.
Thank you so much, Jitender sir. It was very, very educational, and thank you for demystifying this complex topics for us. There are a lot of questions on the chat box. We can take one by one. The first question is from Desiree. She is from Sri Lanka, and her question uh, is this legal guardianship same in every country? She's from Sri Lanka, Jitender. Is
Okay.
there a
Okay. So
yeah,
largely the laws are designed exactly the same. Okay. Not much of difference. Some difference you might see. But if you are asking whether, the one country legal guardianship accepted in any other country, no, it does not happen. So suppose you come to India, you will have to apply legal guardianship in India. Okay, and India might have some specific laws as per the legal guardianship. So to some extent they might be same, but there will always be some differences in the laws.
wonderful? Next question is from Ashok Shah. When can trust be called irrevocable trust, and any government documents required to make it irrevocable trust?
Okay. So there are two situations generally in the trust. Either the settler can decide to convert it to an irrevocable trust. Let's say creating after 5 years, settler decide and convert it to an irrevocable trust, or at the death of the settler, it gets converted to an irrevocable trust. Government documents, so you have to go and get the trust, the document registered again for converting to an irrevocable trust. So you will write a certain kind of document, it's kind of an amendment, okay, to convert it to an irrevocable trust. And it might vary in the state laws, like in UP, in Noida, so you have to get the entire trust deed re-registered, okay. In might some state you might have certain document only or amendment only, to be registered, but you have to go and get the document registered. Okay, also one more thing, on the registration, so also the registration of the trust is not mandatory. It says that if it has only movable asset, you can even get notarized and it is very well acceptable. But if it has immovable asset, then the registration is mandatory. So that is also there in the trust, but we always advise to go and get the trust registered.
Next question from Ashok Shah continues is, can settler also be the beneficiary along with the child? Can settler also be beneficiary along with the child?
Yes, he can be. 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 No problem.
From Hari, is there an objection in the, if there is an objection in the will by the, it's a very specific case, I don't know if you want to answer this. If there is an objection in the will by the grandmother, who is a class 1 higher, can the trust be formed by legal guardian? Parents of special child have passed away. It's a very specific question. I don't know if you can answer this.
No, I'll answer it. See, if the depends on if the trust provision of creating a trust is in the will, so it is going to take time till the will gets contested. But if legal guardian wants to set up a create a trust for the child, the legal guardian can create it. No problem. Trust does not have any relation to the will. Trust is completely a separate process. Okay, whether a will gets executed, contested, it is not going to impact the will, impact the trust. Where it is going to only impact is the distribution of money which is going to come to the trust through the will. That's the only impact it has. But irrespective of the will, the legal guardian can go ahead and create a trust for the child.
Got it. Jitendra, you're there, right? Another question is, can someone help to build trust? I joined late. Ajit, you can send us a message separately, and we will send you the contact of Jitender Solanki. He on a paid consultation, you can get help from. Moving ahead, from Anup. I want to know details process of documents such as making a legal guardian, and please share with me. Arup, I request you to go for a paid consultation. This is beyond the scope of the webinar. That's it, Jitendra sir. Thank you so much for your time. If there anyone else has any questions, can unmute and ask. Ashok Shah has raised his hand. Ashok ji, over to you.
Thank you, sir.
There are more questions in the
Good
chat.
webinar. And good evening, Jitendra ji. The
Yes.
question is, you make a will where you transfer your assets to the child's name, and later you make a trust. Will the child's asset will get transferred to the trust?
Yes, the child asset can be transferred to the trust. So the legal guardian will take that process of transferring the child asset to the trust. It can be transferred because he is the beneficiary, and beneficiary's assets, because the trust is going to take care of that. So beneficiary's asset can be transferred to the trust. That can happen.
But who will do the process of transferring in case
the legal
the
guardian?
Parents,
Legal guardian.
Or can the trustees themselves do the process of transferring the assets?
Sir, trustee does not have that legal authority, because who is going to, make that transfer? So it's a legal guardian who will make that transfer. Let's say it's a property. Okay, let's say it's a property. Now the child cannot make a decision on the property. So only the legal guardian has that legal authority to take the decision on that property. So without legal guardian, it cannot happen. The trustees does not have that legal authority to transfer anything which is there in the name of the child.
So in that case, is it better that to make a form a trust first? And in the will, you write that after the demise, you transfer this property to this trust, which is for a child's benefit.
Yes, certainly. The will should have that clause. The will should have that specification that which asset should go to the trust. So you can even name the trust, and the name of the trust can be written in the will.
And that transfer will be tax-free for the trust.
Sorry?
That transfer of entire assets will be tax-free for the trust.
Yes, it is a succession. It is a succession. See, let's understand, as I explained, trust is not a separate legal entity where it has its legal present like a private limited company. It's a legal arrangement. Whatever is there in the trust, it's there of the beneficiary. So whatever it is coming through will, it's going to be a succession.
And both revocable and irrevocable trust will require a PAN card.
Ashok sir,
Trust.
can I request, can you
Yes.
take these questions one-on-one? I have shared his contact
Okay,
with
fine,
you.
fine.
In interest of time, sir.
Fine. Achha. That was the last
I am
question, Mike.
sharing Jitendra sir's number on the chat box. People can
There are two
approach
more
him
questions, I guess,
directly
on
for
chat.
any consultation.
Okay, there are two more on chat. Question on
Yeah,
chat.
please go ahead, yeah.
Okay, so Prabhas Roy, what is living will and trust? Living trust. Okay. So as I explained, the trust you have two provision. One, either you create trust through a will. So trust formation takes at your death. Living trust is you create a trust today and you become a trustee or you appoint trustee. So you create a trust today in your living and see the functioning. So that's called a living trust. Okay, and you transfer the money today. So it's going to be a living trust. Second, what is a living will? So will talks about assets at the death. Living will speak about that if you reach to a very critical situation, then what should your family members and the medical, the doctor should do. So it's a health directive written for doctors and family members to what they should do when you reach to a very critical situation which is irreversible. So that's a living will. Okay. What kind of corpus required for a special kid lifetime? Is a thumb rule to arrive at a number? Amitabh ji, I think that's a ineffective. That's a separate exercise altogether. Finding out what kind of corpus should come to the trust.
Sure, thanks.
Best way to fund a trust is through a life insurance, right, Jitendra sir?
Yes,
Term insurance.
if you do not have those assets created, okay, best way is to take a term insurance. The best is term insurance. The cheapest form, and whatever the requirement you come out, whatever is the shortfall, just take a term insurance, and I think your trust will be funded whenever the situation
Term
arises.
policy also, can you change that to nominee? You can change from beneficiary child to the trust.
So there is an assignment process. It does not come through nominee. So there is an assignment process. So you assign the insurance to the trust. So through that assignment process, the proceed will come to the trust. Okay. So the order is first form a trust and after that make a will. No, I think, how we do it is we create 5 documents for parents simultaneously. Both parents will, both parents living will, and the family trust. If you can work on these all 5 documents simultaneously, I think the moment you complete this, you are well prepared for the future. Last, once a trust is formed, what legal formalities needs to be done on a recurring basis? Okay, so once a trust is formed, then there are certain compliances the trust have to do. So it will have to file ITR. That's the document with the government you have to do. That's the only thing. Rest of it, there are internal compliances which have to be maintained, like minutes of meeting, decision making, the recording of the decision making. So all those internal compliances are there related to investment, writing your IPS. So those are compliances which needs to be done on a recurring basis. You don't have to report it anywhere, but you need to maintain that compliance. Okay, I think I'm done with the questions.
Thank you so much, sir. Really appreciate your time. Thank you so, so much. It was a fantastic session. Yes, the recording will be shared. The PPT is already shared on the chat box. Ananita, if you can post it